Good afternoon and welcome to today's iteration of the live employment law Q&A by employmentlawyer.ca. My name is Teilen Celentano. I'm an associate and employment lawyer with Samfiru, Tumarkin, LLP, and I work out of our Toronto, Ontario office. If you guys have any questions, please go ahead and ask them, whether directly through Facebook, LinkedIn, Twitter, X, YouTube, and I'll answer them live. You can also email us at employmentlawyer.ca or go to our website at employmentlawyer.ca. Email us at help@employmentlawyer.ca or give us a call at 1-855-821-5900. So I'm going to start today off by talking about the recent news out of Hasbro. The most recent news is that they're laying off almost 1,100 people in the second big staff reduction of the year. So whenever there are big layoffs, big terminations at any company, it's not uncommon for companies to speak with lawyers beforehand and offer severance packages to their employees as they're leaving. What's really important in situations like that is that you don't just accept the first offer. While some offers may seem fair on their surface or may seem generous, there are oftentimes very underwhelming with respect to your maximum entitlements under the law. When an employee is terminated, a court can award as much as 24-month severance to that employee to help them cover bills and expenses until they find their new job. So what's really important is that if you are ever let go, whether for whatever reason, and especially if it's a mass layoff like we're seeing with Hasbro right now, that you give us a call and speak with one of our lawyers who'll be able to review it with you, look at the exact circumstances of your employment, and give you an idea of how fair the offer is and whether it's worth accepting. Another option is that you can use our severance pay calculator. That's on pocketemploymentlawyer.ca, and that can give you a rough estimate of how much severance you would be entitled to really understand how that compares to what's being offered. The second big story I'd like to discuss briefly this afternoon is about the Spanish YouTuber who's suing Google and alleging that he was an employee and not a contractor. The law surrounding employees and independent contractors is continually changing. This is especially true since COVID hit, and more people are working from home. More and more people, have flexible work hours, and the marketplace is really changing. Similar cases are with Uber Eats and their delivery drivers who are also classified as contractors, even though Uber exercises a huge amount of control over what they do. Whenever a court is trying to ascertain the true nature of a relationship, whether it be an employee or an independent contractor, they've said that they look at a non-exhaustive list of factors. Non-exhaustive mean anything that colors in the lines and helps paint the picture either way, the courts will look at it. So a contract that says I'm an independent contractor or so-and-so is an independent contractor isn't necessarily determinative. The court will look at it, but we see cases every day where despite a contract that says an independent contractor, those people are subsequently deemed to be employees. Courts look at a bunch of things, like I mentioned. The four biggest things are control, ownership of tools, integration into the company, and chance of profit / risk of loss. I'll go through those each kind of individually from a very high level. So control is the biggest factor a court will look at. And the control is how much control does the employer exercise on the employee? Does the employer tell the employee what to wear, when to show up, where to work? Does the employer have to approve vacation time? Does the employee set the amount of hours he gets worked or they work, or does the employer? Do they get paid on a piecemeal basis, meaning you get paid for a project, or do you get paid for your time? That's a bunch of things there, a lot more that the court can look at. The second thing, ownership of tools. Who owns the tools that the worker uses on a day-to-day basis to complete their job? If it's the employer, then it would lead a court to believe that person, that worker, is an employee. Third, chance of profit, risk of loss. If your only chance of profit is potential commissions, then you're probably an employee. What the court's really referring to in a chance of profit is if you get paid on a piecemeal basis and you're able to complete the job much quicker than you otherwise estimated, you get to save all that time and do another job. That's a chance of profit. Risk of loss, similarly, if something's behind schedule or something doesn't go well, the amount of money you get paid will go down. That's not the case. If there's no real inherent risk, then you're probably an employee. And again, commissions don't count as a chance of profit. And then the last thing is integration. Are you integrated in the company? Is what you do essential to the company's business? So if you are in management and you're telling people what to do, if you are using a company email, if you are using company business cards, if you're wearing company uniforms, all those things are instances that show integration and show that someone's likely an employee rather than a contractor. So those are my 2 talking points I wanted to start off today with. I'm going to go into answering questions. So our first question today comes from Barker on YouTube. He asks, if an employer provides the employee with a car and fuel reimbursement, can the employee use the car and add fuel for personal usage? So it depends on what the agreement says. So an employer is allowed to give an employee a car to be used only for work, but it needs to be clear. So if you are starting work with a new company, or you're getting promoted, or the company is just giving you a car and they're changing a term of your employment, they are allowed to say this is only for company use. You're not allowed to use this on your personal time. It's important that that's in writing, and it's important that you're given the opportunity to agree to it. If you do choose, notwithstanding that clear direction, to use it for personal use, then you could be disciplined. So it's important that the employer sets a clear standard for what the use is for. If you're unsure, if there is any ambiguity, it's just asking your boss, hey, I want to use this for my own personal use, when I'm not at work, going to get groceries, whatever, and see what they say. And whatever they do say, make sure you get it in writing. Make sure you get it in email. Make sure it's a text message. That way there's some paper trail that if it ever comes up and you unfortunately have to speak with one of our lawyers, then you are in a position, you have that paper trail. So the company can let you use it for personal use. They can also not allow it. Either way, we want to make sure it's in writing. Barker also asked the second question as part of the same comment. If an employee goes on a leave of absence for a medical condition, can the employer ask the employee to return the car, or at least not add fuel, since there's no work being done during leave? Yes, Barker, that is something they can do. While you're on a medical leave, they are not allowed to change your job. And when you are ready to return, they would have to give you access to a company vehicle again. But given you're not working, and given you're not working for the company in any capacity, and you're supposed to be at home and recovering, they are allowed to ask for it back and ask that you not use a fuel card. It's one of those things, though, that when you go back to work, they need to make sure that they're giving you the same compensation package and same position that you had before your medical leave. So, while you're on medical leave, it's not that you have to be a hermit and stay in your house 24/7 and never go out and speak to anybody, but more so that if you're not working and the car is company property, they are allowed to ask for it back. Josh Lentz asks, I've initiated a claim against my previous employer for severance and human rights violations. Is it reasonable to ask for a letter of apology and admittance of the violation? Josh, I'm not that I think that whether or not it's reasonable in a case like this is difficult to say. Pragmatically speaking, it's unlikely that you'll get anything. The reality is, in most minutes of settlement, and almost universally around the world, when a lawsuit is settled, there is no admission of liability. The person paying out the money does not admit any wrongdoing, and in fact, they say, we admit no wrongdoing, and in fact, expressly deny it. So if the only way you ever get a piece of paper saying that they made the mistake, saying that they breached the Human Rights Code or the Canadian Human Rights Act, is if you go all the way to court. Anything short of that, you likely won't get an apology or an admittance or anything from them admitting the violation. And moreover, if you were to settle the matter, then there would be an express provision that says they're admitting no wrongdoing. From the court's perspective, they will say, depending on what they say and depending on what the facts of the case are, they may say that your former employer did breach the Human Rights Act and are therefore liable to pay you extra damages. But what they won't say is that the company needs to apologize. Our courts don't order people to apologize. They generally just order them to pay money and make binding decisions. So, it may be fair and it may be reasonable, it may be understandable in your case, Josh, for you to want to ask for an apology and for to have that piece of paper where they say they were wrong. Pragmatically, though, I don't think it will happen short of a judge saying they were wrong, just because that's not the way the law generally works. Got a question on Facebook from Peter. I was suspended from work for a few days, but I never received any sort of written warnings. I haven't been recalled back to work, and I'm not sure what to do. What happens if they don't call me in? So, Peter, whenever it sounds like you were suspended for disciplinary reasons, and that is an assumption I'm making, so correct me if I'm wrong. But if they've suspended you without pay for the past couple of days, it's likely that you can treat that suspension in and of itself as a constructive dismissal. But especially if they don't recall you back to work for however long, then it is a constructive dismissal, and you may be entitled to severance. If it is a discipline thing, they would probably be making allegations of cause. So it's not a case like that is never open and shut, but cause is incredibly hard to prove. Our courts have said that cause is the capital punishment of employment law, and they use that, some say inflammatory language on purpose to highlight how hard it is for an employer to establish that they truly had just cause to terminate someone. So for you, Peter, it's best for you to give us a call so you can walk through your situation with one of our lawyers, and they can advise you specifically on what you may be entitled to. Again, it could, depending on how old you are and how long you've been there and the other factors of your employment, it could be as much as 24 months severance. So go to our website, employmentlawyer.ca, and so you can set up a call with one of our lawyers and they'll be able to help you out. But in short, if they don't call you in and they don't give you any type of letters or anything else, it's likely a constructive dismissal. And even then, the act of just placing you on a suspension is likely in and of itself a constructive dismissal. So reach out to us and one of our lawyers will be able to help you out, Peter. Carlos on YouTube asks, does severance pay change depending on the size of the company? So Carlos, there are two different types of severance. The first one's under the Employment Standards Act, and the second one is under the common law. They offset one another, so it doesn't really change. Technically, under the Employment Standards Act, yes, in order to receive under the Employment Standards Act, you're entitled to 8 weeks termination pay, 1 week per year of service, up to a max of 8, and then an additional 1 week per year of service, up to a max of 26 in Employment Standards Act severance pay, up to a max of 26, provided the company has a payroll over $2.5 billion and you've been there for longer than 5 years. That being said, under the common law, which runs concurrently and is offset by your ESA, the size of the company doesn't matter at all. So whether you work for the biggest company in Canada, biggest company in the world, or you work for a mom and pop shop with 4 or 5 employees, under the common law, which is where most of our cases are governed, you're entitled to the same amount of severance. So I think the short answer is technically yes, but realistically no, Carlos. The amount of severance you're entitled to doesn't change based on the size of the company. And one of our lawyers will be, if you were to speak to one of our lawyers, they'd be able to explain this in more detail and apply it specifically to the facts of your case and really give you an idea of what you're entitled to. Susan from YouTube asks, what goes in a demand letter for unlawful reprisal, being terminated for reporting health and safety issues and unpaid hours of vulnerable sector employees? Can you ask for your job back? Susan, it's, reprisals are always a difficult situation. Under the Occupational Health and Safety Act, there's an express prohibition on reprising, i.e. retaliating against someone for making a formal complaint, like it sounds like you made, but in the same breath, it's difficult. Those cases are difficult to prove. And you can, in theory, ask for your job back, but there would be no obligation on the company to give you your job back. And generally, unless you're a federally regulated employer, reinstatement is exceedingly rare, especially if you were to send a demand letter, retain a lawyer, and send a demand letter or sue. It is likely that the employer wouldn't want to have you back in the workplace because it would no longer be a productive relationship. So I think in a case like yours, Susan, it seems like there's a lot of balls in the air, and it'd probably be best for you to reach out and speak to one of our lawyers who will be able to draft the demand letter on your behalf. Obviously, we all have tons of experience drafting these types of letters and navigating these tricky situations and making sure that we don't step on a landmine that we can't see. So, I mean, the short of it is you could ask for your job back, Susan. I don't think it would generally doesn't make sense because it never happens. Reinstatement rarely, if ever, happens. So in your case, if you wanted, but if you do want to do something like that and do send a demand letter, I would suggest speaking to one of our lawyers who will be able to help you out and navigate through that process. Nancy on YouTube asks, if an employer cuts your hours to reduce your pay instead of changing your wage, is that looked at the same way as cutting your pay directly? So Nancy, it depends. Yes, it is. The short of it is yes, it is. But when that change happens, a court will always look at how substantial the change is, right? So if you're going from, let's say, 37 and a half hours to 35 hours a week, right? So instead of having a half-hour unpaid lunch every day, you're having a 1 hour unpaid lunch every day. And that results in, $100 less a week in your bank account. While that is, obviously a significant change and underhanded, that change probably isn't significant enough to warrant a finding of a constructive dismissal and entitling you to severance. So it needs to be a substantial unilateral change is what the courts have said. So if they've cut your hours by 20, 30, 40, 50%, and accordingly your pay has reduced by 20, 30, 40, 50%, then yes, that court would look at it the same way. They would likely treat it as a constructive dismissal, and you would be entitled to a full settlement package worth as much as 24 months' pay. So it's really a contextual thing, Nancy. Of course, judges and courts are aware of the fact that, especially for hourly employees, cutting hours is another way of cutting pay, and it has the same effect, and it makes it difficult for you and everyone else in those situations to pay their bills. So yes, a court would look at it similarly, but again, the change needs to be substantial. If it's a very minor change, like I said, half hour here, half hour there a week that they're cutting, it's probably not enough for constructive dismissal. But if it's 20, 30, 40%, then you're probably in the right and will be able to pursue it. So if it is a big change, if it is that kind of change, reach out to us. One of our lawyers will be able to talk you through it. Reggie from YouTube asks, when should you speak to a lawyer if you're told you can't be brought back after a maternity leave? Reggie, right away. Under both the Employment Standards Act and the Ontario Human Rights Code, employers have to both first accommodate a pregnancy and then return the person to the same work afterwards. That goes both for maternity and parental leave. Our courts and the legislation has shifted away from maternity leave and instead shifted towards parental leave. So it doesn't only apply to the people who had the baby, who gave birth to the baby, but it also applies to their partners and people who are adopting children. Any new parent is entitled to take a leave of absence from work in order to take care of their child. And if an employer is choosing not to return you to work or is choosing to return you to a substantially different position at a different rate of pay, then that is not only a constructive dismissal or just a straight up termination, but it's also a breach of express provisions, the Employment Standards Act and the Human Rights Act. Our courts don't look favorably on companies who choose to do that, who choose to ride to keep the replacement on and cut the person who just went off on a parental leave. And oftentimes those people are ordered to pay additional damages for breaching the person's rights under those acts. So if a company says we can't bring you back after your maternity leave, or if a company says we're changing your job and you're going from a manager to a supervisor after your maternity leave, then when should you speak to a lawyer? As soon as you find out. Give us a call. One of our lawyers will be able to help you out, help guide you through the situation. I'm sure there's likely going to be a future email exchange, and through that exchange there could be, again, a number of landmines you could step on, and which could hurt your case. So as soon as you know that your employers are bringing you back, reach out to us, and one of us will be able to help you out. Wayne on YouTube asks, what if the insurance company wants more evidence when my doctor has approved my return to work? Can they stop me arguing modified duties and why I need them? When I'm not sure exactly what you mean by insurance company. If it's a company that is accommodating the return to work process, then the company is entitled, and that insurance company is hired by the company. They are allowed to ask for more information. Now, they're not allowed to make a decision that contradicts your doctor, right? So if your doctor says you're ready to go back to work, they're not allowed to just say, no, you're not. But if they're trying to understand more about the situation, if they're trying to make sure they understand the full scope of it, then they are allowed to ask for more. And you do have a duty to comply with it. So, it depends on what they're looking for. If they just want a doctor's note and you haven't provided one yet, then yeah, you do have to provide a doctor's note. If they want you to fill out a functional abilities form, which outlines what your restrictions and your limitations are, rather than just a simple doctor's note, they can also ask for that. Now, if they want highly specific medical information related to your condition, what exactly you were diagnosed with, how you were treated, that kind of stuff, that doesn't need to be shared. But they are allowed to ask for more information with respect to, your leave or your return to work, because they also have an obligation to accommodate you, right? They can't just, they need to make sure that when you return to the workplace, they are accommodating your needs, however they may be. So if you can no longer do this, or you can no longer do that, lift this or use a ladder, they need to know that, and then they need to accommodate it. Because if they don't ask those questions and they don't accommodate you, then they are breaching express provisions of legislation. So you do have to cooperate with them. You don't have to give them everything. You don't need to tell them what happened, but anything related to when you can go back to work, whether or not you need a gradual return, and what modified duties you may need, you do have to comply with that. Aaron on Facebook asks, I worked for a company as a sales rep for 18 years and was classified as a contractor. I was terminated in January when they changed their whole sales structure. They said that they followed the law for our terminations, and since we are not employees, we were not owed any substantial severance. Is this accurate? No, it's not, Aaron. This is what I touched on earlier today. Just because you are labeled as a contractor doesn't mean you are not entitled to anything. So a contract that says you're an independent contractor isn't determinative of the issue. It's likely, most salespeople, most commissioned salespeople, despite what most people think, despite what companies might tell you, most of those people are employees rather than independent contractors. And even if you're not an employee, there's also a classification called a dependent contractor, where our courts have said, even if you're a contractor, but you work solely for one company, receive the majority of your income from one company, and are completely dependent on one company for all of your income, then you may not be an employee, but you're also not an independent contractor. You are instead a third middle group of a dependent contractor. And as a dependent contractor, you are still entitled to severance. So Aaron, if you worked exclusively for this company as a sales rep for 18 years, didn't make any substantial earnings from other sources, they're wrong. You are entitled to something. You are entitled to substantial severance. I obviously don't know how you work at, or how old you are, Aaron, and how much you made and some of the other circumstances of your employment, but you could be entitled to a package worth anywhere from 18 to 24 months, depending on the other circumstances of your employment. So no, they were wrong. They were inaccurate when they said they followed the rules, or that they followed the law. So it's really important that you reach out to us and talk to one of our lawyers who can help guide you on what you're entitled to. It's especially important because you're about halfway through the limitations period. In general, you have 2 years from the date on which you are terminated to start a lawsuit. Now, there are things that can affect it, but in general, that limitations period is 2 years. So you're already about halfway through that, Aaron. So it's really important that you reach out to us, and one of our lawyers will be able to help you out. Gio, what can you expect when filing a constructive dismissal complaint under the ESA? How does it work? So, Gio, it's very rare that I recommend that a person file a constructive dismissal complaint under the Employment Standards Act on their own, rather than filing a statement of claim with the Ontario Superior Court. And there's a bunch of reasons for it. So, a constructive dismissal is a concept that exists both under the Employment Standards Act, but also under the common law. And you are entitled to termination pay, severance pay under both avenues as well. However, the Employment Standards Act sets out only your minimum entitlements, meaning the minimum things a company absolutely has to do to follow the law. There's almost always a lot more money on the table to go through a formal lawsuit, file a statement of claim, instead of just an ESA complaint. So, putting that into more context, under the Employment Standards Act, the most you could ever receive is 34 weeks pay. Recently, through the courts, some people have been provided as much as 26, 28, 30 months pay. So yes, while you can file a complaint under the ESA for constructive dismissal, my advice would be to give one of our lawyers a call, and they'll be able to help you file a formal complaint or formal statement of claim, file a formal statement of claim to really make sure that you're getting all the meat off the bone and you're not leaving anything there. So that's the first thing. But to answer your question more directly, when you file anything with the ESA, you're initially assigned to a first level claims investigator. They reach out to both parties, give you both a chance to settle it. If you choose not to, when you choose not to settle it, then it gets forwarded to an investigator. That investigator investigates the claim, makes a decision, and then you're forwarded the decision. The investigator may also ask you for additional information or documentation. Whole process can take anywhere from 3 to 8 months, depending on how complicated the matter is and who the investigator is. Carter on YouTube asks, how long does an employer have to hold a job for someone on sick leave? Carter, it depends. There's no bright line rule. There's no formal date that says it has to be that, anything longer than 2 years, they don't have to hold the job. Now, you can hire a temporary replacement. You can temporarily promote someone into the position that the person who's on sick leave held before they got sick. But there's no bright line rule that says it has to be this long. Can't be anything longer than this. Our courts look at things contextually, look at a number of different factors, and try to ascertain whether or not it's reasonable for the employer to still keep that job open. The biggest thing the courts look at and want to see is whether or not there's a prospect of returning, right? So, of course, if there's an acute injury, right, someone's in a car accident and are in the hospital, the prospect of them returning isn't foreseeable at that point, and because it just happened, that makes sense. But if it's been a prolonged medical leave, we're talking anything 6, 8, 12 months, the courts then want the employer to reach out to the employee and say, hey, I'm trying to understand how much longer you're going to be away from, and what's your prognosis on a return to work. If there remains a foreseeable future where the employee will return to work, and the employee is making constant steps to work towards it, there's really no length on the maximum amount of time. As long as the employee is trying to come back to work, making those steps and showing progress, the employer will have to keep that job open and return the employee to work when they're ready. That's my last question for today. Our live next week will be hosted by my colleague Luke Serta, 3 p.m. Eastern time. Last question is from Susan again. She says, when you fill out Form A53 for unlawful reprisal, do you have to put CEO as contact? As the person who did the unlawful reprisal, or can you just put the chair of the board of directors as the contact? Generally, you just put the 1-800 number. Someone from the company just needs to be in contact with it. But if it's a CEO or the board member, as long as somebody from the company is being spoken to about it, that's normally good enough. So that's my time for today, everyone. Thank you for tuning in and asking your questions. We really appreciate it. Hope you have all have a great holiday season, and tune in to our next show if you have any more questions. Thanks. Bye-bye.